Welcome to Channel AMEC, your insight to the Australian visa system. Good day everyone, my name is Carl Young, your online YouTube visa consultant. Are you interested about migrating to Australia? Why don't you consider to subscribe to my channel and turn a little bell on the side, so once we have all the updates and news, you'll be the first one getting all the insight. Now today's video we're gonna talk about employment sponsor visa. There has been a very hot topic over the years, as a lot of people they have equipped themselves with the experience and also the English proficiencies in wanting to gain Australian residency as soon as possible. So why not utilizing subclass 1A6 direct entry so you get permanent residency straight away? Well, yes, technically, yes, this is the question, and the answer is very easy. Obviously, any migrants will want to get permanent residency easier, faster. No one will say no. However, we're going to talk about how hard is it to actually get it. Although we can actually see how there is an opportunity for employment sponsor 1A6 visa, ENS with a direct entry to get your permanent residency straight away. But you got to consider how hard it is. Why do I say that? Let's jump in there and have a look at the criteria for employer. Let's put on our spec and think about this. If you're an Australian employer, would you like to sponsor someone and provide them a residency straight away? Question mark. Perhaps not. Let's have a look. Okay, so obviously I've done a specific video on subclass 1A6 under what they call employer nomination scheme with the direct entry stream. Now, why does it call direct entry? Because that directly provides you a permanent residency straight away. So you can see this visa allows skilled worker who nominated by the employer live, work in Australia permanently. Obviously, that isn't options. A lot of options that a lot of migrants would love to have. That's for sure. But would an Australian employer, or would any employer, want their employee to get that residency that soon? Perhaps not. Why? We need to think about this. What if your employee will actually get a residency straight away? What can they do? What options do they have? Additional options that they can have? Well, they can easily, if they have the residency straight away, I tell you what, under the law, they could easily break the agreement to actually work for the employer. Although you do have the right as an employer to report the employee to the Department of Immigration or Department of Home Affairs. However, that's going to be a lengthy battle, and that go through appeal, and a lot of legal costs and time going to consume. So you got to think about this. If you're an employer, would you want to open yourself up for that kind of potential dispute? Perhaps not. Well, of course, if you have a good employee or employer, that won't be an issue. But there's no perfect world. Obviously, we would like that to be happen, but over the past, with the experiences, and you got to think about this. Now, employer, they're not dumb, right? They do have their own legal advisor, their lawyers. If they go to their lawyers and they go, oh wow, look, can we do this? And what is the risk going to involve in there? If you are a professional lawyer and a legal advisor, you would, and that's your obligation to provide all the potential risks that's going to involve for this employer. And then obviously, employer will think about whether or not they're going to provide that direct entry to the skilled migrants straight away. And that's the first thing. That's the hardest part to get through, I tell you. But anyway, we'll examine every other detail in this video for you as well. Let's go back to the immigration web page in regards to direct entry. So now you have noticed that I have toggled this page to meet the sponsor's requirements. So let's go into the eligibility as a sponsor. So you will know, oh, that's a best sponsor eligibility. Now, there's not much to read here. but still a lot of information is required. Why? Let's go into detail. Okay, it says your business, so the sponsor's business, the employer, had no adverse information. That means you have paid your tax right, you have done everything right. Now, I'm not saying somebody who has any bad records will actually affect this, but look, if you're in a small business and perhaps you have missed out one of the tax date and pay the tax, would that deem to be an adverse information? I'm not too sure. If you're a large corporation, there's obviously potential dispute in the past record there. Would that also categorize as adverse information? So again, the employers are required to go to their legal advisor and get all this clear before they could actually commit to this, and they have to be actively lawfully operate. Now, how do you show this? Obviously, the employer is required to provide all their taxation documentation, all their financial statements, all their the business activity statements that they lodge every quarter, and make sure they have paid all the taxes. They need to print out their tax agent portal showing that the balance is zero, there is no money owed. Look, some business, because they had previously a large lump sum of tax, they may utilize their accountants to request paying tax in installments. Now, I have seen that. Now, does that deem, well, they are still legitimately operating business in Australia, but would that deem to be an adverse information again? I'm not too sure. But again, for a skilled migrant, obviously your employers are gonna tell you this. Okay, and they will go through their legal advisors, and the advisor will go, wow, well, if you do have this, do you want to open yourself up to another departmental authority of the government, allow them to know about your past? Perhaps not. So that's another reason why there's a lot of the complexity involved in an employment sponsor visa. There is sometimes when you meet the employer, they're very nice, but they are reluctant to help on visa. That's another thing that could block you from getting employment sponsor. If they undertake activity related to hiring, labor, now they are business in Australia. Well, they are lawfully operating as a hiring agent, so they assist you to find another employer. So they are an agent or consultant. Now it's a different, so there's a lot more complexity in this, because you're technically involving three parties. So you as the employee, and the agent for the brokerage agent, and the actual employer. Now the employer doesn't pay you directly, they pay the broker agent, and the broker agent then pay you. So that's another complex part. Okay, so it's the three party, the more party involving here, the more complexity increase in that case. So again, that's another thing that perhaps might block you from getting sponsored as well, because you don't know how you get a job. You may found a job from Seek.com, from Indeed, from online, but did you know a lot of these job ads is not actually posted directly by the employer themselves? They went through a agency, a brokerage company, to help them out. So again, that's another complex part. Now, next point is have a genuine need to pay employment. Now, that's pretty sure if they want people to be here. But I'm gonna take you back. Let's going back to the overview, and let's toggle this back to applicant. Now, what I'm here to show you is, look at this processing time. Remember what we have just mentioned about the whether or not they are genuine position. Now, because 90% of the application is required to wait for 12 months. Now, that's a crazy thing that the previous government, the former government, had made. Now, the employer is going to come back and ask themselves whether or not they will still be a genuine position 1 year later. So today is, say, June 2022. Do I still need you in June 2023? 3, and perhaps you're overseas, you're not even in Australia, why am I gonna spend time and money putting all this application, paying all this money, and waiting 12 months for someone to come to actually work for me? Do I still have that genuine need? Now that's another thing that a lot of employers will go and they will think about whether or not they're gonna do this sponsorship for you as well. Now, last but not least, let's skip the word relation law, because workplace relation law, because they're gonna comply with that anyway. But last but not least, the Skilling Australian Fund. Let's have a look at this. This is a crazy cost, which I believe that the new government, perhaps they were required to get rid of them. So if we look at this application fee, that's only a couple hundred. Oh look, that's fine. Did you as I had mentioned in one of my previous video, the employment sponsor had the cost for the employer had jumped from $10,000 to $25,000. $25,000. That's not even including the wage I'm gonna pay for the employee. Yet, while waiting for 12 months of paying that kind of money, where does it come from? Here we go. Look at this, calculating the levy. If you look at this, this is a crazy thing. Now, if they're gonna go through, we go through ENS, right? So that's 186. If they're gonna be a small business, they're gonna pay $3,000 one-off. Or if they are turning over 10 million or more, they're gonna pay straight away $5,000 to the government straight away. Now, knowing that, paying that $5,000, and that's just $5,000, that's not even including all the legal and the visa process and all that kind of fees. And you know that the potential employee will come 12 months later. That, if you are the employer, what would you think? Okay, you got to think about this. If this guy got the PR, he may choose to leave and all kind of things. Do I want to get into that trouble? And secondly, well, not saying if they not getting PR, they only get TSS visa. It's more than less likely they will leave, because they will continue to work until a certain point. 3 years later, they can transfer into PR, so they are unlikely to leave. But if they get PR, they may leave. They may change. They may relocate themselves. Secondly, the cost, and thirdly, waiting for 12 months. Okay, and fourth, the employers open up all their taxation and financial record to the government of Australia for the Department of Home Affairs. Do you, as an employer, like to do that? Now, obviously, there are employers still willing to do that. They are large global corporations, and they are really looking for talented people. But if the employer, they are small size and medium sized businesses owners, they may think twice or perhaps 3 times after they chat with their legal advisor. And that is the major thing that block everyone from getting a 186 direct entry straight away. Anyhow, should you have more question query, more than welcome to leave a comment right down below, and I'll see you next video. Goodbye.